Hello, everyone. Welcome to this lecture. We were talking about the EIA and different perspective it does have and the historical progresses it has been developed through. So we were talking about Article 8 of the 1991 Antarctic Environmental Protocol. The Antarctic regime is for the conservation, protection, preservation of the environment of Antarctica, which is the fundamental, uh, and of course, as a continent which does have the balance uh, for the global temperature, for the global balance. Uh, the scientists have continuously been exploring the resources, particularly unique biodiversity, life forms in such extreme temperature beneath the iceberg. So finding those are actually some unique experience and paves the way for the opportunities for the future exploration and exploitations of many more natural and mineral resources. Therefore, the significance is to protect and preserve the Antarctic environment. So there also the mechanism of EIA has been continuously installed to make sure that it does go with. Then it says that in case of this evaluation, after ending the whole procedure of evaluation, it must be made open for people for 90 days. So this is the model of EIA under the Antarctic Environment Protocol says that EIA result will be kept open for public after it being conducted. The data, the analysis, and the results shall be made public for 3 months so that people can comment on it and different stakeholders can have their participation in it. As you all know that Antarctic doesn't uh, have any what you call it territorial sovereignty of any states. Usually there are enormous farms who are conducting research, scientific research, and continuously attempting to explore in the area. So for them also, and it is one of the expensive tourist destination, which is why the Antarctica is a very vital considerations for the global community. So this is why that EIA, in case of EIA, public participation is a crucial issue, which as we see that reflected in the Antarctic Environment Protocol. The long-standing work of International Law Commission on Prevention of Transboundary Harm from Hazardous Activities 2001 provides in Article 7 that any decision in respect of the authorization of any activity within the scope of the present article shall in particular be based on an assessment of the possible transboundary harm caused by that activity, including the environment impact assessment. So, in case of transboundary installations and establishments, International Law Commission's draft article clearly mentions about the assessment to be made for the purpose of you know uh, for the purpose of mapping whether the activities are going to cause any harm to the environment in the transboundary nature. So that is very important. Therefore, if you understand International Law Commission as a body formed by the globally renowned experts of international law of different regions, and they are bestowed the task of following and contributing to the progressive development of international law. So the work of International Law Commission has a significant value. It has an impact on the society, on the international community, and many drafting articles of International Law Commission are considered as reflection of customary international law. The way they do reports and research is truly amazing. And if you read some commentaries of any report of International Law Commission, you will find the range and level of analysis by including reports and materials in such an enriched way that it does possess certain value. Therefore, the reference of ILC with respect to the EIA has again put the issue more emphasized for the international community. We move ahead with the UNEP draft principles of conduct. As you all know, that UNEP has been a pivotal organization after Stockholm being established in Nairobi, for the purpose of global environmental protections under the rubric of United Nations. And it has been contributing with best efforts globally for the protection and preservation of the environment, for making out the possible causes which contribute to the deleterious environmental degradation. These are some of the issues UNEP is supposed to works and focus. So UNEP had this draft principles of conduct adopted in 1978, and in the principle 5 of that conduct, it says that states should make an environmental impact assessment before engaging in any activity with respect to a shared natural resource which may create a risk of significantly affecting the environment of another state or states sharing that resource. So, UNEP draft principle says that the state should make an EIA before engaging in any activity. Uh, and again, it talks about the transboundary range of resources. Now, because within the domestic sphere and the domestic resources, states have this obligation, and most of the states have the domestic law to deal with the issue. But when the question of the transboundary EA is concerned, other than Europe, you actually do not have any other regional or global obligations which can directly prescribe the country to comply with EIA mechanism. And as we all know that natural resources are in many instances are shared by nations. For example, Sundarban, one of the and it is the largest mangrove forest. Uh, having its territory. If you look at it, it's not only Bangladesh alone can pose. It's also the West Bengal of India has a certain part of it. Therefore, this is a shared natural resource. Then, if you look at a desert, for example, Sahara, which is in between so many nations. You can look at Nile River and many other instances. One of the unique examples can be given in the law of aquifers. The groundwater of, let's say, Israel is actually within the groundwater, within the ground Syria, for example. So there are some interesting phases. And also with respect to the coil rig or other natural resources, where it is actually the remained a shared resources. And some lakes, for example Victoria Lake in Africa, Eastern Africa, so three countries uh, have the have the shared of this resource. Therefore, in order to install any projects, it is no doubt that the nations should, pursue to follow the environmental impact assessment, thereby to ensure that proper, I mean, the shared resource is properly maintained and managed. Otherwise, there are severe problems with respect to the management of the shared natural resources. Um, of course, the model of European regional convention style would no doubt be the best solution, but again, one can continuously be arguing the the minimal minimal range of possibility. I mean, it's not at all possible for many regions to have or to come out with certain ideas about these resources, which is why the challenge still exists. Now, in the next lectures, I think we will have some of the discussions related to the possibilities and finding avenues in this regard. So, with that, we conclude this part. Thank you very much.